Welcome all, my dear friends. Let us continue our journey in the world of patents. Today's key term is compulsory licenses. Okay, friends, till now we have discussed up to form number 16 and its relevant sections and rules. Okay, so now it's the turn for form number 17. Okay, and the key term for form number 17 and its relevant sections and rules is compulsory licenses. Fine. So compulsory licenses, or what is so here we will try to analyze what is compulsory licensing in a literal way and how it is significant in the world of patents. Okay. Okay, so next, in the next slide we will try to analyze the literal meaning and the meaning in the patent world. Fine, let us proceed. Friends, as we know that the key term for form number 17 is compulsory licenses, so you can see here that compulsory license indicates form number 17. Fine. So now we will see what does it mean literal. Okay. So compulsory means that must be done, plus license, compulsory license. Okay. So what is the meaning of license? License is an official permission to do, use or own something. Now this is the literal meaning of compulsory license or compulsory licensing. Now we will see how compulsory license is defined in case of, or we can say in the world of patents. Okay, so let us see. A compulsory license is an official permission by the government allowing someone else to produce the patented product or process without the consent of the patent owner. Fine. So you can very easily differentiate between the literal meaning of the compulsory licensing and the meaning in the world of patents. Fine. Then form number 17. The title is Application for Compulsory License. Okay. Here the related sections are 84, 91, 92, 92A. And the related rule is only one, that is rule number 96. So we will discuss briefly about all the sections. Section 84 is compulsory licenses. Section 91 is licensing of related patents. Section 92, special provision for compulsory licenses on notification by central government. Section 92A, compulsory license for export of patented pharmaceutical products in certain exceptional circumstances. Fine. And rule number 96 says application for compulsory license, etc. So here the keyword is no need to explain. The keyword here is compulsory license. Fine. Next we'll proceed to form number. After refreshing our memory from the old slide where we had established the relationship between form number 17 and its relevant rules and sections, let us proceed for a specific section today. And today's section that I have taken is section number 92, and this comes from chapter 16, whose title is Working of Patents, Compulsory Licenses and Revocation. And friends, one thing I would like to tell you that the title for section 92 is, just take a look here, this is Special Provision for Compulsory Licenses on Notifications by Central Government. So let us have a detailed explanation in the next slides. Fine. Okay, so let us proceed. Section 92 has in total 3 subsections. Okay, and I have taken some keywords or key terms or key phrases as per my convenience, as per my intellect. Okay, so you can choose your own. So let me tell you about those. Okay, for subsection 1, the key term is circumstances. For subsection 2, the key term or key phrase is the grant of licenses. Okay, and for subsection 3, this is the controller is satisfied is the key phrase. Fine. So this way, if I can, that means please try to remember these keywords or the key terms or the key phrases, so that by remembering this we can easily recall the specific subsections of a particular section. Okay, so let us proceed. Subsection 1. Okay, this says if the central government is satisfied in respect of any patent in force in circumstances of national emergency or in circumstances of extreme urgency or in case of public non-commercial use, that it is necessary that compulsory licenses should be granted at any time after the sealing thereof to work the invention, it may make a declaration to that effect by notification in the official gazette, and thereupon the following provisions shall have effect. That is to say, clause number 1. The controller shall, on application made at any time after the notification by any person interested, grant to the applicant a license under the patent on such terms and conditions as he thinks fit. Okay. Now, clause 2. In settling the terms and conditions of a license granted under this section, the controller shall endeavour to secure that the articles manufactured under the patent shall be available to the public at the lowest prices consistent with the patentees deriving a reasonable advantage from their patent rights. Okay, so friends, here I have written a relevant rule, that is rule number 96, whose title is application for compulsory license, etc. Okay, so here the key term is circumstances, and let me explain you this the gist of this subsection in a very simple way. So just listen carefully, okay, and try to understand. Okay, okay. Under circumstances of national emergency, etc. That means it can include extreme urgency, public non-commercial use, etc. etc. Okay, so I'm again telling it. Under circumstances of national emergency, etc., if the central government is satisfied that it is necessary to grant a compulsory license in respect of a patent in force, it shall give a notification in the official gazette. This is the simple meaning of the first part. Okay. The first point is, after the first point, or this comes from first clause. Fine. After the notification is made, any interested person may file an application for the grant of a compulsory license, and the controller shall grant a license under the patent with such terms and conditions as he thinks fit. Okay. So I am again telling you, after the notification is made, any person interested may file an application for the grant of a compulsory license, and the controller shall grant a license under the patent with such terms and conditions as he thinks fit. Fine. The second point, or that comes from the second clause, just listen carefully. Okay. In setting the terms and conditions, the controller shall take care that the patented article is available to the public at the lowest price consistent with the patentees deriving a reasonable advantage from their patent rights. Okay, so I hope the gist of this subsection is pretty much clear. Okay, and as in the below, I have actually mentioned rule number 96. Okay, so rule number 96 is, the title is application for compulsory license, etc. And I can just tell you a very interesting fact here. Just listen. Any interested person may file an application for the grant of a compulsory license at any time after the notification in the official gazette in Form 17. Okay, along with the required fee on such terms and conditions as he thinks fit. Fine. So actually, this is, we can say, just a second. Actually, the last statement, what I said, comes from clause number 1. I'm again telling it, so try to understand it. Okay. Any interested person, okay, because here we can see any person interested, or we can say that any person interested may file an application for the grant of a compulsory license at any time after the notification in the official gazette in form number 17 along with a fee of, that means the required fee, on such terms and conditions as he may think fit. Now it is clear, I guess. Okay. So this way, friends, subsection 1 is pretty much clear, I hope. Okay. So let us proceed. Subsection 2 says, the provisions of sections 83, 87, 88, 89 and 90 shall apply in relation to the grant of licenses under this section as they apply in relation to the grant of licenses under section 84. Here the key phrase is the grant of licenses. Okay. And here, friends, I don't think there is much to explain here, but still let me tell you the provisions of sections 83, 84, 87, 88, 89 and 90. They shall apply in relation to grant of licenses under this section, that means section 92, as they apply in relation to grant of license under section 84. That means a comparison has been made here, nothing else. The procedure will be same. Okay, that means the provisions as for this above sections starting from 83, 87, 88, 89 and 90, they shall apply in relation to grant of licenses under section 92 as they were applying in relation to the grant of license under section 84. Just a comparison has been given here. Okay, so the relevant sections are Section 83, that is general principles applicable to working of patented inventions. Section 87, procedure for dealing with applications under sections 84 and 85. Section 88 is powers of controller in granting compulsory licenses. Section 89 is general purposes for granting compulsory licenses. Section 90 is terms and conditions of compulsory licenses, and section 84 is compulsory licenses. That's all, friends. So I hope it is clear now. So let us proceed for the next one. Subsection 3 says, notwithstanding anything contained in subsection 2, where the controller is satisfied on consideration of the application referred to in clause 1 of subsection 1 that it is necessary in clause 1, a circumstance of national emergency, or clause 2, a circumstance of extreme urgency, or clause 3, a case of public non-commercial use which may arise or is required as the case may be, including public health crisis relating to acquired immunodeficiency syndrome, that is AIDS, human immunodeficiency virus, HIV, tuberculosis, malaria and other epidemics, he shall not apply any procedure specified in section 87 in relation to that application for grant of license under this section, provided that the controller shall, as soon as may be practicable, inform the patentee of the patent relating to the application for such non-application of section 87. Here, friends, the key term or the key phrase is the controller is satisfied. Okay, and the secondary key terms are national emergency, extreme emergency, public non-commercial use, such non-application of section 87, etc., etc. So let me analyze this subsection in a very simple way. Just listen carefully. Okay, where the controller is satisfied upon consideration of the application that it is necessary in case of national emergency, extreme urgency, public non-commercial use, including public health crisis such as relating to AIDS, HIV, TB, malaria or any other epidemics, he shall not apply the procedure as specified in section 87, provided that the controller shall, as soon as practicably possible, inform the patentee for such non-applicability of section 87. Okay, fine. So I hope The essence of this subsection is pretty much clear now, and I will try to explain the whole gist of this subsection by taking an example. Okay, so just listen carefully. National emergency does not have a standardized international definition. Fine. It is a challenging task to have a standard definition because each country has their own health problems. Having a fixed, narrow, and rigid definition of national emergency is a hard task actually. Okay. For example, having a disease affecting or having a disease afflicting 2% of Indian population is equivalent to approximately we can say 2 crore 50 lakh people, whereas the same percentage of Canadian population is equivalent to 0.6 million people only. Okay, so for India, this is a national emergency, but for Canada, this is not at all a national emergency. Fine. So we can say that other parameters may also vary from country to country. This is just an example. Also, friends, if you think a bit for the current situation, you can also find out the COVID situation in India. When we are talking about the statistics, the percentage of affected people, the people dying, they are very less compared to our population. Percentage is less, but still we know actually what happened. Fine. So this is just an example. I hope now it is pretty much clear now. Okay. So please, actually all the subsections of section 92 are completed. So please go through them all. Please go through the barract as well. If you have any confusions, you can write them in the comment box. Okay. So we have heard about the terms like voluntary license, compulsory license. Okay. So let me just compare between the two. Okay, so what is voluntary license? Voluntary license is an official paper that shows you are allowed to do or have something, or you have the permission to enter or use the property of another. Right? This is a simple. That means license means in normal terms, whenever you utter the term license, it is voluntary license. Fine. And then what is compulsory license? Compulsory license, it is a legal document by which a bank, building, society, etc. lends money at interest in exchange for taking title of the debtor's property with the condition that the conveyance of title becomes void upon the payment of the debt. Fine. So I hope now you can differentiate between these two. Fine. The reference is Patents Act 1970 as amended by Amendment Act 2005 and the Patents Rules 2003 as amended by Amendment Rules 2021. So friends, please like, share and subscribe the channel. Thank you all for listening to me and thank you all for watching my video. Stay safe, stay blessed. God bless you. Jai Hind.